Equally, the sterling qualities which we have described must be possessed by an election commission are indispensable for an unquestionable adherence to the guarantee of equality in Article 14. In the wide spectrum of powers, if the election commission exercises them unfairly or illegally, as much as it refuses to exercise power when such exercise becomes a duty, it has a telling and chilling effect on the fortunes of political parties. Inequality in the matter of treatment of political parties who are otherwise similarly circumstanced unquestionably breaches the mandate of Article 14. The election commissioners, including Chief Election Commissioner, blessed with nearly infinite powers and who are to abide by fundamental rights, must be chosen not by the executive exclusively and particularly without any objective yardstick. This is what Mr. Owaisi also quoted in his debate. Independence must be related finally to the question of what is right and what is wrong. A person whose weak-kneed before the powers that be cannot be appointed as an election commissioner. A person who is in a state of obligation or feels indebted to the one who has appointed him fails the nation and can have no place in the conduct of elections, forming the very foundation of democracy. An independent person cannot be biased, holding the scales evenly, even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and the wronged, who are otherwise in the right, would qualify as true independence. Then Law 297, para 297. We have set down the legislative history of Article 324, which includes the reference to what transpired, which in turn includes the views formed by the members of the subcommittees and members of the Constituent Assembly. They unerringly point to one conclusion. The power of appointment of members of the Election Commission, which was charged with the highest duties and with nearly infinite powers, and what is more, to hold elections not only to the central legislature but all the state legislatures, was not to be lodged exclusively with the executive. It is accordingly that the words subject to any law to be made by Parliament were undoubtedly incorporated. Pausing here for a moment, my lord, clear indication in this judgment, in this paragraph, that you cannot have a law which will again vest the power dominantly with the executive. Although it says subject to a law made by Parliament. Then Lord 301. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shots in the manner of appointments to the Election Commission. 7 decades have passed by. Political dispensation of varying hues who have held the reins of powers have not unnaturally introduced a law. A law could not be one to perpetuate what is already permitted, namely appointment at the absolute and sole discretion of the executive. Clear statement that the law cannot have this feature where the appointment is essentially by the executive. A law, as Mr. Gopal Shankar Narayan points out, would have to be necessarily different. The absence of such a law does not create a void or vacuum. Does create, sorry. This is despite a chorus of voices, even cutting across the political divide, urging divesting of the exclusive power of appointment from the executive. So opposition people were, when you are in opposition, you say that. When you come to power, you forget it. This is what was happening.
Most unfortunate part.
Yes, my lord. One can say a great deal about many unfortunate things that are happening, but at least this was one which was dealt with by this court. 303. Political parties undoubtedly would appear to betray a special interest in not being forthcoming with the law. The reasons are not far to seek. There is a crucial, vital link between the independence of the Election Commission and the pursuit of power, its consolidation and perpetuation. As long as the party that is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in the saddle. A pliable election commission, an unfair and biased overseer, of the foundational exercise of adult franchise, which lies at the heart of democracy, who obliges the powers that be, perhaps offers the surest gateway to acquisition and retention of power. So, I would say, my lord, so deep, prescient, precise statement. 306, we bear in mind the fact that the demand for putting in place safeguards to end the pernicious effects of the exclusive power being vested with the executive to make appointments to the Election Commission has been the demand of political parties across the board. Once power is assumed, however, the fact of the matter is that despite the concerns of the founding fathers and the availability of power, successive governments have, irrespective of their color, shied away from undertaking what again we find was considered would be done by Parliament by the founding fathers. This is the reason. While this court is neither invited nor it is invited, nor if it is invited, would issue a mandamus to the legislature to make a law as contemplated under 324(2), it may not be the end of the duty of the court in the context of the provision in question. We have already elaborated and found the core values of the Constitution, including democracy and the rule of law, are being undermined. It is also inextricably linked with the transgression of Articles 14 and 19. Each time, on account of a knave, in the words of Dr. Ambedkar, or again in his words, a person under the thumb of the executive calls the shots in the matter of holding the elections, which constitutes the very heart of democracy, even formal democracy, which is indispensable for a body polity to answer the description of the word democracy, is not realized. In the unique nature of the provision we are concerned with, and the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values, as also the fundamental rights, we are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists on the basis that, unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a transient or stopgap arrangement. They are saying that the court's direction is a transient and stopgap arrangement, and now we can bring any law. And it was to be replaced by a law made by Parliament taking away the exclusive. And it was to be replaced by a law made by Parliament taking away the exclusive power of the executive. Very clear. The conclusion is clear and inevitable that in the absence of law, even after 7 decades, points to the vacuum. And that is why, my lord, they laid down. Then, my lord, your lordship may turn over. And now I may quote some paragraphs of the Scora, just a couple of paragraphs, page 11, your lordship may turn. Scora, your lordship knows, was the case where the court brought primacy to the judiciary in the matter of appointment of judges. 209, my lord, at page 11. The aforesaid discussion leads to an inescapable conclusion that all the factors mentioned above coalesce to support the view that the executive will not be justified in enjoying the supremacy over the opinion of the CJI in the matter of selection of judges to the superior judiciary. And then, my lord, at the bottom of the page, independence of judiciary. Independence of judiciary is a sine qua non of democracy. So long as the judiciary remains truly distinct from both the legislature and the executive, the general power of the people can never be endangered from any quarter. Montesquieu, in his book Spirit of Laws, observed, there is no liberty if the power of judging be not separated from the legislative and the executive powers. The framers of the Constitution made it known in an emphatic voice that separation of the judiciary from the executive, which is the lifeline of independent judiciary, is a basic feature of the Constitution. B.R. Ambedkar in his speech said, I do not think there is any dispute that there should be separation between the executive and the judiciary, and in fact all the articles relating to the High Court as well as the Supreme Court have prominently kept that object in mind. then, my lord, we respectfully agree with the concept of judicial independence as enunciated by the Supreme Court of Canada. In the above quoted judgment, it is not the security of tenure provided to an individual judge alone which is the source of independence of the judiciary, but there has to be an independent judiciary as an institution. The judiciary in India has to act as an impartial umpire to resolve disputes between the governments and private individuals, as well as between the governments inter se. It has also to protect fundamental rights of individuals guaranteed under Part 3. The courts in this country have already expanded the scope of judicial review by bringing in its ambit social, economic, and political justice. Keeping in view the expanding horizon of judicial review, it is of paramount need of the time that not only independence of the individual judge is to be secured, but the independence of the judiciary as an institution also to be achieved. Then the question which comes up for consideration is, can there be an independent judiciary when the appointment of judges vests in the executive? To say yes would be illogical. The independence of judiciary is inextricably linked and connected with the constitutional process of appointment of judges of the higher judiciary. Independence of the judiciary is a basic feature of the Constitution.